Volodymyr, welcome. I can hear you. So good morning to everyone. Volodymyr, welcome at the second stage of the selection process to the High Qualification Commission of Judges of Ukraine at the interview stage. The interview will be conducted by the Selection Commission, represented by its full composition: Yevhen Mesentsev, me, Ivan Mishenko, Tatza Zhachny, Serhiy Verlanov, Stephen Markman, and Robert Brookhuizen. The rapporteurs at your interview are Tatza Zhachny and Yevhen Mesentsev. So, Volodymyr, in case any technical problems occur during the interview, don't worry, we will postpone the interview, we will reach you and appoint the interview for the other date in case this happens, and we will start with the place where we were interrupted. Questions will be asked. Please give your concise answers, and the member of the commission asking the question can actually limit your answer. And before the interview, you will have some time, up to 5 minutes, to tell about your motivation, about your ideas related to the reform of the judiciary, in case you have any views, and the reform of the High Qualification Commission of Judges of Ukraine. With this, let me give the floor to my colleagues, Yevhen and Tad. You're welcome.
Thank you, Mr. Chairman. Good morning, Mr. Luhanskyi. I may call you Judge Luhanskyi because, of course, you had a very distinguished career as a judge. And I'm going to take just a moment for the rest of our viewers to acquaint them a little bit with your background. By my calculation, you are 57 years of age. You have been a prosecutor for approximately 17 years of your professional career. You then became a judge in the Luhansk Oblast. And as I understand it, you advise us that you were deputy head of the Luhanskyi District Court of Luhansk, and then you became judge head of the court in 2015 and served in that capacity until 2020. So that provides us a little bit of your history. You are married, you have two daughters, and they are well on their way. So with that, Mr. Luhanskyi, I am going to turn the matter over to you and have you spend a few minutes telling us of your motivation seeking appointment as a member of the High Qualification Commission of Judges of Ukraine. The floor is yours, sir.
So I'm Luhanskyi Volodymyr Ivanovich, born on October the 30th, 1965. After 8 years of school, I started my studies at the Chemical Vocational College, and then I worked as a locksmith in Azot Enterprise. And in 1986, I was conscripted to the army, and I also went to Afghanistan within the service, and after that I came back to my enterprise, worked as locksmith then. Then I entered Kharkiv Law Institute, which I graduated from in 1991. And after my graduation and up to 2008, I held different positions in the prosecutor's office of Luhansk region, starting with the investigator, deputy prosecutor in the town of Rubizhno, the prosecutor of the town of Kirovsk, Pervomaisk, then head of the investigative department of the prosecutor's office of the region, prosecutor of the city of Luhansk, head of the department of enforcement of penitentiary sentences. And in 2008, I became a judge in Luhanskyi District Court. Then I was deputy chair of the court, deputy chief judge. Then I started working since 2015 till 2020 as the judge in Severodonetsk town court. And then I was the chief judge of it. I've got a PhD in philosophy of law, and since 2011, I've got it. I was within my thesis dealing with Article 382 of the Criminal Code of Ukraine. I'm the senior justice, the senior advisor in justice, and I am the third rank judge. Now I am in the armed forces of Ukraine. And as you have mentioned, I've got a wife and two daughters. My wife is the judge, and now she's Ivano-Frankivsk Appellate Court, and I'm staying here at the interview. Thank you. That's all.
Thank you very much for that further explanation of your career.
And you also asked about motivation. Sorry, I forgot to answer this question. So my motivation was that, well, it's a little bit lyrical deviation, but I can tell you that in the armed forces of Ukraine, among paratroopers, we have the slogan that, who if not we? In the Soviet Union, the slogan was a little bit different, nobody but us. But now they are really, the Russian paratroopers are dying in our country. But now we have changed the slogan, who if not we? So I think that since I have the necessary background, who if not I'm going to help the state with the selection of good judges, motivated and people of integrity. That's it. Thank you.
Yes, thank you for those additional comments. I was studying some of the material that we have with respect to you, Mr. Luhanskyi, and in particular, I was interested in your career as a judge and deputy head and then head of your court. And you tell us, among other things, that you were responsible for the administration of the court as well. Can you tell us a little bit about the size of the court and the size of administration that you were responsible for?
Well, as a deputy chief judge, normally his authorities are guided by the chief judge. So as a deputy chief judge, I was more responsible for the materials and for the technical provision of Luhanskyi District Court. And the conditions of work were not the best possible because we had to obtain new premises. Our premises left a lot to be desired. And as deputy chief judge, I was settling the issues starting with paper, stationery, and up to computers and all the other things, all the inventory that the court needed to ensure its adequate functioning and operation. That was my mandate of the deputy chief judge. And when, of course, the chief judge was not present, I had to perform his duties.
And what is the size of your court? How many judges did you have in your court?
15 judges. It was very difficult to work because it was not enough. We had actually 15, but 6 or 7 of them only could perform their functions because for some of them the 5-year term had expired. Some were on their vacation, some were on a leave, on sick leave, and the load of judges was very, very high.
Yes, and of course, sir, I ask you these questions because I'm interested in how you will be able and what you will be able to bring to your role as a member of the High Qualification Commission. And I want to focus upon that question for just a moment. You say, I think very well in paragraph 2 of your motivation letter that judges should show tact, politeness, consideration, respect the participants of judicial proceedings, not show disrespect or discrimination, adhere to moral and ethical norms of judicial conduct, and that these things have great importance for the formation of public opinion as to the judicial power in general. Those in...
Yes, because these are all integrity criteria that judges should comply with,
Right.
both judicial candidates and incumbent judges, and you need to follow those integrity criteria. A judge should not be guided by emotions. He or she should be guided by common sense and by his mind.
Right. Now, how would you propose to judge judicial candidates for the qualities that I have just repeated and that you have proposed? If you were to be a member of the High Qualification Commission, what would you look to judge a candidate and whether or not he can comply with these values that you have discussed with us?
Well, the law actually says that we have the methodology, we have the procedure for assessment. I cannot tell that they are ideal and perfect, but they are good. But you know, any system and any reform requires some improvement, and any mechanism, actual real mechanism, like the car engine, well, that is also a system, and our law system is a system that has always room for perfection. So I think that we should take the system we have for the assessment of judicial candidates and for incumbent judges, but it should be improved in terms of being more flexible. Well, that's what I think.
Now, you discontinued...
The system is good.
All right. You indicate that you voluntarily retired from the court in 2020. And I'm wondering what the reason was for your discontinuing as a member of the court.
Well, I did not decide not to continue with the court, but I retired because my wife is a judge and I'm a judge, and the load on judges was very high. And my daughter was 8 or 9, and we needed to take care of her and of her studies, help her with her studies. I didn't say goodbye to the judiciary. My documents are still with the High Qualifications Commission for holding the position of the judge of Luhanskyi appellate, of one of the appellate courts. And so I was intending to participate in the context. And to get ready for this competition, I needed to have some free time. And if I was a lawyer, I could have enough time for that. While being a judge and having that load, I could not get ready for this position of a judge in the appellate court. That's why I decided to do it like that. I worked for 30 years holding civil servants positions, and I decided that I need to try my hand at practicing law. And by the way, I didn't have enough time for that because of the war. And that was actually the reason why I retired from court.
All right. One last question. You make the point that among the biggest problems with respect to the judiciary, and I suspect you feel this way about the High Qualification Commission for judges as well, is that in your view, the representatives of other branches of power are trying to subdue the judiciary to their own interests, using different mechanisms of influence. And I would appreciate your discussion of some of those mechanisms of influence and whether or not you think you need to be concerned that they will also be exercised against the High Qualification Commission of Judges should you be a member.
Well, answering this question, I'd like to say that while I worked as the chief judge, I always felt that both the prosecutor's office, administration, like top officials, had some requests. They kept coming to the chief judge, and local authorities kept coming. And quite often, I faced the situation when there were requests made. They asked me to have some decisions passed in favor, and they told me that this decision would be legitimate. So I faced such situations with influence, with mechanisms of influence, and a judge should be independent and incorruptible, and I think that this is the main thing. Everybody should deal with his own business. Prosecutors should deal with prosecution, local self-government bodies should deal with their business, and judges should do their business. There should be no influence exerted on them. Judges should be guided by their inner feeling and understanding. I'm sure that such situations happen quite often. That's why I think that the criteria of integrity is one of the most important criteria. The judge should be incorruptible, impartial, unbiased, and the judge should be ready that he may get some requests and offers, and he should be able to use diplomatic ways to reject them. And you should always act on the basis of your inner understanding within the limits you have set for yourself. You should know that there is the law, and you should be following the law. As far as the law is concerned, you should be conservative about it. You should always pass legitimate decisions and not the decisions asked for. That is my answer to the question.
Just to follow up on that answer, are there any structures or any proposals which, as a result of what you have just told us and your experience as the chief judge of your court, when there are different mechanisms of influence that members of the High Qualification Commission might face, is there anything or any structures that you can propose to prevent that from occurring or to deal with it if there are such attempts?
Well, the most important thing here is the judge's psychological mentality. If the judge is really ready not to have any compromise and just to comply with the law, that is the most important thing. And that's why we should select good people, people of integrity, because these are the people who will never have any illegitimate compromise with security services, other bodies. I think that it all depends on the personalities of the judges, of the members of the High Qualification Commission. That must be a person of will, a person of integrity. And he should always be acting within the law.
All right. Thank you for your answers. I am going to invite my colleague, Judge Mezentsev, to now take over the questions.
Thank you.
Good morning, Volodymyr. I'm Ivan Mezentsev, and let me discuss several issues with you that are primarily related to your motivation. So Ted started this dialogue with you concerning your vision of the development of the judiciary, of the High Qualification Commission and its functionality, but I haven't heard any clear answer. So you mentioned that you think it is necessary to introduce more scrutinous verification or inspection procedures for judicial candidates. You have mentioned that it's necessary to study the way of living of the candidates over the previous years, but these are general truisms. So what specific mechanisms could you suggest for the HQCJ to go deeper into this aspect, to have better inspection and examination than we now have? And why are the vettings that we have now not quite suitable? I cannot tell that they are not suitable. I have mentioned that the system is quite good. I didn't mention that the system is bad. The system is quite good, again. But any reform should not be delayed, because any delays lead to injustice in the judiciary. Yes, it's clear, Volodymyr, but the point is that in your motivation letter you mentioned that vettings and inspections should be more scrutinous. So by what means? I don't know, polygraph testing or study of the assets abroad, or what are the ways of making these inspections deeper? Well, as far as polygraph is concerned, I would not recommend it because that is intervention into the personality, and criminals probably can be tested if they want to, but judges, I don't think that we can ever have any examination using polygraph testing. We should be checking the motivation of the person for becoming a judge. Maybe we should also introduce more scrupulous motivation psychological testing. I mean, the psychological testing that really checks whether the person is motivated, whether the person is prone to collaboration or not. And to check whether a judge who has taken the oath to one state can give the oath to another state, to be a collaborator. So to check this in order to avoid such situations. Okay, clear. Let's discuss another question. Several minutes ago, you mentioned that a judge should be using some diplomatic means to reject offers. Do you mean offers of any illegitimate enrichment, or what do you mean by offers? Well, offers could be different. If offers of illegal enrichment or other offers, and it's necessary to have the skill of explaining that you won't be doing this. Yes, but you mentioned that you should be using some diplomatic ways. So what about the judge? Should he be so much diplomatic? Maybe he should inform the High Council of Justice and NABU about that right away, not just to be diplomatic and to stop this offer from coming into effect, but to also create the grounds for punishing this person who is making offers like this. Why diplomatic? I think that probably no diplomacy should be at stake here. Well, of course, the judge should inform NABU and the High Council of Justice, but sometimes there may be offers that are kind of hidden ones. You cannot inform about those hidden things which you cannot actually explain what is offered. Yeah, but I'm just arguing about this word diplomatic. So what kind of diplomacy could be here? I mean that sometimes when you communicate with the top level officials and they make some offers and you show them right away that you won't be doing this, you will never make any other office like this after that. That would be great. But if they keep insisting, then we should, of course, inform whenever you have any clear ground for reporting about this. Thank you, Volodymyr. We have also studied your property, your assets, your real estate, including, unfortunately, the property located in the occupied territory. We don't have any special remarks concerning your property. We've got your explanations, but still we've got some minor issues and reservations. On the 2nd of December 2020, you and your wife sold the apartment that belonged to you in Luhansk. You sold it in compliance with Ukrainian legislation via the notary who was staying in Severodonetsk. Yes. Along with that, on that very day, you gave a power of attorney for the disposal of this apartment to Mr. Tkachenko. What was the reason for giving this power of attorney to Mr. Tkachenko, and why did you need this? Why taking this civil action? Well, that was done upon the request of the buyers of the apartment because, by the way, I have this purchase sale agreement in my hands now. Mr. Ivanytsky pointed it out that the purchase sale agreement in the territory of Luhansk region, the so-called Luhansk People's Republic, right? So-called people, yes, sure, so-called Luhansk People's Republic will not be considered valid there. So they are owners, according to the Ukrainian legislation, owners of that apartment. But he asked me to issue a power of attorney for his relative because the relative could show this power of attorney that they can enter this apartment because the Ukrainian agreement would not be valid for the authorities of that so-called Luhansk People's Republic. But that's what made me frustrated. If the occupation authorities do not accept civil acts of Ukraine like purchase sale agreements, why should they accept the power of attorney issued by that same notary on that very day? Well, I was also frustrated by that, but people asked me if that could help them, so why not? They just wanted to show the authorities that they had the right to enter this apartment. I also asked them the same question. You've got agreement for purchase sale. You will show it, it will have the same effect, but they said that no, we will not show it because we will not have it accepted. So it was a rather strange situation. Okay, let's go over to another question. In your declaration, you mentioned quite an amount of cash, you and your wife, about $70,000 in total. What are the sources of such savings? Well, first of all, my salary was always quite high, and I was a combatant, so I also get some bonuses. My wife also has high salary, since she's the judge of the appellate court. So in total, step by step, we were, by the way, declaring all this, and these savings do not exceed our salaries, our income. Okay, thank you, clear. You have also indicated in your declaration several cars. In particular, in 2017, you had UAZ car declared. As far as I understand, this is an off-roader, but it's kind of a primitive one. Yes, exactly. So concerning this UAZ car, in your declaration, you didn't indicate the value of the car. Well, other trailer, something else, and some VAZ car were indicated in the declaration with the value. Why did you not indicate the value of this UAZ? I was not the owner of this UAZ. The owner was another person. I don't remember the surname of this person. I just had a power of attorney for this off-roader. But my father bought it out from the owner, and he did this for 30,000 hryvnias. I was not the owner. That's why I didn't indicate its value, because I even didn't know what its value was. Okay, clear. Thank you. Because I have a hobby, hunting, and this was just for hunting purposes. We took it with my friends to, yeah, it's clear. But the goal of using it has nothing to do with the declaration, right? Please do tell me. Now, we already have some concepts of the intensified role of civil society in the selection of judges and exercising control over the development of the judiciary. And these concepts are manifested in the following. The High Council of Justice has just approved the anti-corruption program for 2023-2025, and it's stated there that the role of civil society should be more important, in particular conclusions and opinions of PIC. And these conclusions of the PIC could be refuted and rejected only at the general meeting of all the composition of the HQCJ and PIC and with an overwhelming majority. So it means that you can reject the negative opinion of the PIC only if you really have this majority at the meeting. And besides that, the EU community and civil society organizations claim that while selecting judges to the Supreme Court, the selection commission should study the issues related to the judges, and all these commissions should have 3 Ukrainian experts and 4 foreign experts, which means that foreign experts will play a major role. So what do you think about this trend? Is this trend useful and justified, at least for now? Or do you think that probably that is some lack of balance in the selection of judges? I think that it is a useful trend, and cooperation with the Public Integrity Council and foreign experts should really take place. And the Public Integrity Council is important. They say that even if something is written about somebody on the fence, you need to check it. So the Public Integrity Council checks all the information it gets. And the Qualification Commission should also cooperate with the Public Integrity Council and treat the information provided by the Council in a serious and adequate way. At least treat this information with respect, but with some reserved criticism, in the sense that, really, there should be some voting. And I agree with this new idea of voting at the meeting. Okay, and what do you think? Suppose you become a member of the HQCJ and you have an opportunity to lobby certain amendments in the law regulating the judiciary of Ukraine. What do you think? Would it be useful and positive to give over some mandates and competences, the procedures of the HQCJ for outsourcing? I mean, assessment of the general skills of the would-be judges could be assigned to expert bodies of the Ministry of Justice, or the issues of financial monitoring could be handed over to some bodies like the Department of the Financial Monitoring of NABU, for their conclusion to be the final one, binding one. Would you think that this would be useful or no? Or shall we leave the procedures as they now are for the members of the HQCJ to deal with them fully? I think that cooperation should be there. But it is the HQCJ that is created for making the conclusion on a certain candidate. So I think that this is still the job to be performed by the HQCJ in cooperation with the bodies which you have mentioned. Okay, clear. So that was my last question. And let me give the floor to my colleague, Robert Broekhuizen. Robert?
Thank you, Robert Broekhuizen. Mr. Luhanskyi, you just said, I noted down, that the system in the judiciary is quite good. And if I understand what you said, you say that the real problem in the judiciary is that there are not enough judges. Is that a correct summary by me?
Yes, absolutely right. In Ukraine, we have more than 2,500 judges lacking or judicial vacancies in the court system. So your summary has been perfectly well. And we really need to accelerate the selection process, the qualification assessment of incumbent judges who have not yet passed it, and the judges whose 5-year term has expired, and would be judicial candidates, I mean, new judges.
Okay, thank you. Well, I have in front of me a report from USAID regarding the assessment of progress in building integrity and tackling corruption in the Ukrainian judicial system of 2021. And in that report, it is described that, according to USAID, the makers of this document, the real difficulty in the judiciary is the fact that there is a limited trust in the judiciary. And if I will read it to you, the new Justice 2021 national surveys on the judiciary show that public trust in the judiciary is on a downward trend, with only 10% of people stating fully or mostly trust the judiciary, as compared to 60% in 2018. And it's perceived to be one of the 5 critical social problems in Ukraine. It also shows that the majority of people working in the courts have difficulty with the trust in the judiciary. And all this lack of trust and the idea that there is corruption in the judiciary has resulted that there was found to be the need of building a clean judiciary. And to clean judiciary, it was found to involve external actors, foreigners like me. What is your comment to that?
Well, as far as trust in the judiciary is concerned, you're absolutely right in saying that the level of trust is very low, and let me explain why. The point is that trust is predetermined by the results of work. Why are the armed forces of Ukraine trusted? Because they can see the results. The enemy is being rebuffed and repelled, or at least curbed, and the armed forces are attacking the enemy and defending the state. You can see the result. So it's all about the result, and the result in the court system is case consideration and hearing and enforcement of sentences and decisions. When I was writing my PhD on Article 382 of the Criminal Code, which deals with non-enforcement of judicial decisions, I was writing my PhD thesis on that topic. And back in 2011, the level of enforcement of court decisions was 32% only. And for some categories of cases, it was even lower, up to 8%. In Germany, it's, for example, more than 80%. So we can see that even if a person goes to court, he or she may get the decision, but he or she never knows whether the decision is going to be enforced or not. And that is what shapes up the trust or distrust in the judiciary, because people are interested in the result, in case hearing and sentences, in enforcement of sentences and decisions. And then a person gets, well, either a punishment or gets some decision in his favor. If this, well, it depends on the category case. The result is either punishment or some remuneration, compensation, or whatever. And this will improve the level of trust. So only efficient work of the judiciary will raise this level of trust. And if this level of trust is low, well, that's true, but people anyway are still going to courts to protect their rights. Yep. That's actually my answer.
Okay. If I say to you, that's, let's say, a position, that's my position, if I listen to what you say, is that if you want to accomplish change, is it then a good idea to appoint someone who is 58 years old, who has had a career in the judiciary for a long time and is retired, because the level of trust was also built during the period that you had a leading position in the judiciary. So why would we recommend someone who has been part of the system that resulted in such low trust to build a new HQCJ? To build a new judiciary and HQCJ. Why would you be suitable for this? I would say, if I look at with my eyes, that you should never select someone who has been part of what has been accomplished. Exactly, you have to look at the results.
Well, you're right. I really worked in law enforcement, in the judiciary for many years. But it's an advantage on the other hand, because I know it from the inside. I can partially agree with what you say, because really we should give way to young people who are not in the system, and young brains are always better than old brains, but experience also matters. Experience gained by people, and 57, it's still not that old, I would say.
I quite agree to that.
So I still want to live, and I can become a judge still of Luhansk Appellate Court. I can become a judge of the Supreme Court by some chance. By the way, I was always a patriot of my Luhansk region. I didn't want to become the judge of the Supreme Court or something like that. But when I had to leave Luhansk region, then I've got different wishes. And by the way, my wife also participated in the competition to the Supreme Court. So what I mean that I was a patriot of my region, but now we have the so-called Luhansk People's Republic. But anyway, I'm still a patriot of my region. I, by the way, have the key to my apartment in Severodonetsk now, and I still believe that I will one day enter my apartment, in spite of the fact that everything has been stolen from this apartment. So that is my answer that to your question, that I still have a lot of energy. And since I'm working in the armed forces, you can see that this energy is still there.
Yes, I can see that you are clearly in a very good condition and a strong guy who still wants a lot. But again, looking with my eyes to you, if I read your documents, what I also see is that your wife and yourself have been able to acquire quite a substantial wealth. I see many, many land plots, I see real estate, I see a lot of cash money. And again, it is the same question. Why? And maybe let's do it from another perspective. Let's say that you sit in my chair. Let's say that we have to judge candidates like yourself. Let's say that we see someone who is 57 years old with a large experience, who was part of the system with a low trust, who also is married to a high judge, a Supreme Court judge, and has been acquiring quite substantial wealth during his life being a judge. Is that someone who should be proposed in this important position? Or should it be someone who is indeed completely beyond doubt?
Well, let me give you a rather skeptical, ironic answer. So, I went as a volunteer to the armed forces, so that's what I can do. But I cannot be a member of the HQCJ because I'm too old. So it's kind of disproportion. If I'm suitable and fit for the army, I think that I am also fit for the HQCJ. I've lived for 57 years, and I've got rich experience. I didn't steal anything. I have earned everything in legal ways only. And all my life has been legal, so just I have earned everything with my mind and the mind of my wife. I've got no gifts, no donations. If you have a look at the cars, well, I bought my last car at the very low value, but I also did repairs because, I was a locksmith and I'm actually an engineer. I know how to repair cars, and I actually improved the car together with my father, and we gave this car to the armed forces of Ukraine. Well, maybe the car is already destroyed. I don't know what is happening to it at the moment. And now when I get my salary in the armed forces of Ukraine, I have a rather high lifelong salary. That's why the major part of my salary, and this can be confirmed by the judges of the Appellate Court of Luhansk region, because I still keep contacts with them. I spend the major part of the salary on the repairs of different cars. And the bonuses paid by the president are also spent by me on that. So I try to repair the cars for the armed forces of Ukraine, for them to function properly, in particular for the unit where I have my service to function properly. Yes, my life has been rather long already, but I earned everything with my own mind, and nobody can just tell that I had any corrupt schemes involved.
Thank you
That's
for your
what my
answer.
answer.
Thank you for your answer. I will pass the floor to my colleague, Mr. Markman.
Thank you for your participation, Judge Luhanskyi. The Commission is appreciative of that. Judge Luhanskyi, you speak of your experience throughout the motivation, and clearly you have very impressive experience as a prosecutor, as a judge, and in other respects. But let me ask you specifically, how would you bring to bear that experience if you were to be placed on the High Qualification Commission? It seems to me that as a head judge, you brought your experience to bear by talking to your colleagues on the court and providing them with what seemed to me to be pretty good judgment as to how they should act as a judge. But what specifically has your experience taught you over the years that would be helpful in counseling your colleagues on the High Qualifications Commission? Instead of talking to them about the moral and ethical norms of being a judge, as you spoke to your colleagues about when you were head judge, what kind of guidance would your experience allow you to provide your colleagues on the High Qualifications Commission?
Being a member of HQCJ, well, it doesn't mean that I will be making the decisions myself. It's a collegial body, and as a member of a collegial body, I will offer my proposals, taking into account my experience. I will be introducing my proposals for everyone to discuss them. So this is how decisions are made by collegial bodies. The same applies to a panel of judges when we hear criminal or civil cases. And this is similar for HQCJ. And truth is born via debate and discussion. When we have a discussion, with regards to improvement of legislation and the procedures of HQCJ, then I think that the result will only be positive.
Well, I think we...
And thank you for your question.
Judge Luhanskyi, of course, I think we all hope that your counsel would be positive. But as my colleague indicated, there are at least some concerns that some have that perhaps your age should not be looked at as a positive factor. I don't know that I agree with that, but some people may think that. So I'm asking you, what has life taught you? What has your experience given to you that perhaps might not be as well understood by some of your younger colleagues on the High Qualifications Commission? I guess I'm asking you to focus, if you can, a little bit more specifically on the lessons of life that you've learned, and doubtless there have been many such lessons, but how will those lessons specifically assist you in providing whatever kind of leadership you can to your colleagues? I understand it's a collegial body, but what has life taught you about how you're going to make the very difficult decisions concerning which candidates for judges are sincere and genuine and who have integrity and which don't? It's a tough question. We're faced with that question every day too, as you can imagine.
I indeed have a lot of experience, and it's not the first war that I've participated in. I've fought in Afghanistan, and since 2014, I've helped the Aidar battalion. Now, I've volunteered to defend Ukraine as part of this invasion. Well, the motivation is that we need to have Ukraine as an independent country, and we need to have qualified and motivated judges working for this country. And I'm used not to follow my emotions, but to follow reason in everything that I'm doing. So any decision that I make must be reasonable. And the same should apply to the work of HQCJ. And one should be able to motivate their opinion. And if I'm able to do that, if I'm able to justify my opinion while being a member of HQCJ, and this opinion is accepted by other members of HQCJ, and it's seen by them as one that is reasonable and feasible, then it will be a positive result of my work within HQCJ. It will be benefit both to the judiciary and to the work of HQCJ in particular. This is how I see it. And here comes my work and life experience. And it's not the end of my life. I still want to have many more years to live, and I want to serve in the army. I still want to work for my country. Be it a judge or a lawyer, maybe I'm going to become a judge once again, but thank you for this question. This is my answer.
Well, let me ask you the same question, but in a little bit different way. I apologize for asking the same question, but to me it's a pretty important question here. You have had considerable experience, and you've seen reforms, judicial reforms in Ukraine come and go. And here we are back with another reform. And you would be an indispensable part of that reform if you were placed on the High Qualifications Commission. And if one of the younger members of the commission said to you, Judge Luhanskyi, you've seen reforms come and go. This one has got to be different. What would you say? What would you say to them? What's been done wrong in the past and what needs to be done right this time? Is there anything in particular that comes to your mind? How are you going to make sure that this reform works? It's got to work, doesn't it? How many efforts at reform can we make before people just get tired of reforms?
Yes, I agree with you. But there is always room for improvement. And this is what I'm going to say to this younger colleague, that there's always room for improvement. And any reform, maybe the reforms that we used to have were not that bad, but they weren't completed. And as I've mentioned already, it's the result that matters. If we are talking about enhancement of the level of trust in the judiciary, then we are talking about the result of their work, and the same applies to HQCJ. If people see the result of our work, if we are able to improve the procedure of selecting judges, then it will always be for the better, both for the good of the country and the judiciary. I'm not saying that we need to eliminate all the previous efforts. We can improve on something that has been done already. For instance, we've had the Criminal Procedure Code of Ukraine of 1960, and it was completely abolished, and we created a new criminal code. And I was not in favor of that, even though the previous code was adopted during the Soviet times. But we can now see that the result of having a new criminal procedure code is not that good. And we are constantly improving on this code, and there's always room for improvement. So this is my answer.
Judge Luhanskyi, you talk in your motivation about the importance of what some call the separation of powers, the relationship between the branches of government. And you talk about the need of the judiciary to be independent from other branches, and you talk about other branches sometimes attempting to influence the judiciary. But the separation of powers involves reciprocal or mutual responsibilities. What does the judiciary have to do to avoid infringing or interfering with the responsibilities of the other branches of government? It's a two-way thing, isn't it?
Yes, I absolutely agree with you. It's a both-way thing, but every judge should follow those limits that are foreseen by the law, the limits of the influence that can be exerted upon them and the influence that they can have on others. When we are living within the society, we are not isolated from other people. A judge is not isolated from any political processes because they do go to the polling stations and they vote for political parties, but there are limits to all of that.
Is it fair to say that one of those reciprocal
influence upon judge can be exerted only by the law. So the law is something that the judge should be following. So this is my answer.
I think that's a good answer. You have an obligation to work under the law that's been given, even if you don't totally agree with that law. Is that correct?
Yes, absolutely. I totally agree with you.
Let me ask you one final question, please, Judge. You say that a person who embarks upon a judgeship or who pursues a judgeship has an obligation to act in accordance with ethical standards even higher than other citizens. You say that in your response to question 10. Working as a judge, a person agrees to undertake even more significant limitations relating to ethical norms. Why precisely is that? Why should a judge exercise even higher levels of integrity and standards of conduct and ethics than people in other very responsible positions?
We are talking about judges specifically because the judiciary is one of the branches of government. We have the legislative, executive, and the judiciary branches of government. And a judge administers justice on behalf of the state of Ukraine. And if you lack integrity, it means it's a crime. That is why there should be more requirements with regards to judges as compared to regular citizens. And judges should be following not emotions but reason when making their decisions. And they should keep their emotions at bay. And I quite often had to do that throughout my career. It's hard when emotions interfere with your activities, and I'm even introducing these principles while serving in the armed forces. You need to keep a cold head. The moral qualities of a judge are very important because people are watching you. People are observing the way you are behaving. And when I was a member of a panel of judges and people were following us, they saw that some of my colleagues on the panel were using their phones during court hearings, and I just told my colleagues that they shouldn't be doing that because people are watching us. I told them, you shouldn't be using your phones. You should listen to what the parties are saying. So those judges were not involved in the hearings. I'm saying that a judge should be an example of behavior as far as property behavior is concerned, as far as moral and ethical standards are concerned.
So the judge needs,
So this is my answer.
so the judge not only needs to act properly in accordance with high standards of ethics, but he has to give the appearance of that as well. Is that what you're saying?
Yes, yes, absolutely. A judge should behave in such a way that they are an example for others, including moral and ethical standards.
Thank you, Judge Luhanskyi. Let me introduce my colleague, Judge Verlanov. Thank you again for your time.
Thank you, Stephen. Good afternoon, Volodymyr. Thank you for participation in this selection. I have the following questions for you. So you have already told us that you've had quite a lengthy career. We've discussed it already. So between May 2008 and September of 2020, you were working as a judge. You also worked at district and city courts. So the question is, what motivated you to retire? I've already answered this question. Well, first of all, my daughter was 8 at the time, and I needed to help her with her studies. And secondly, I participated in the selection for the judge of an appellate court, and I needed some time to get ready for that competition. And I also wanted to try working as a lawyer, but I didn't manage to do that. I didn't manage to have a fruitful career as a lawyer because the war broke out. But I did have several cases in which I participated as a lawyer. So I didn't say goodbye to the judiciary by retiring. So it means that you had some objective reasons to retire, right? Yes, and now that's clear. Thank you. And now you are saying that you applied for this selection to be appointed as an HQCJ, but before that you applied for the selection for a judge of a court of appeals. Yes, but that was some time ago. Thank you. While answering our question about increasing the level of trust in the judiciary, you mentioned that while selecting candidate judges, in addition to qualification assessment, we need to pay specific attention to the integrity criteria. And you specified that this criteria is about the behavior of the judge, and this behavior should be based on proper relations between the citizens, between members of the society, and the state as a whole. So my question is, how do you understand integrity of a judge within the context of this principle suggested by you? Good relations with citizens, with the society, and with the state. Could you please explain that? Yes, I've already answered this question. It's important that a judge feels limits. As far as integrity is concerned, they have to have this integrity, but they also need to have diplomatic and tolerant relations with all the parties to the judicial processes, but also this kind of relations with members of the society. So there should be a reasonable approach. There should always be some limits. Yes, thank you. Thank you for this answer. So we've received a letter from civil society organizations asking us about your travels to the territory of Russian Federation after 2014. If you traveled there, could you please explain the circumstances of those visits? I did not travel to the territory of Russian Federation. Before 2014, in 2013, I've already told you that since hunting and fishing is my hobby, I traveled to Russian Federation with this purpose. And as a person who participated in the war in Afghanistan, I used to have some comrades who served together with me, but they are no longer my comrades. I sent some pictures to these so-called comrades, and I mean those comrades from the Afghanistan war times, they started telling me that Ukraine was intending to invade Russia. That's why I'm no longer in touch with these people. But before 2014, I did travel to Russia and met some of them. After 2014, I did not cross the border, but in 2015, I crossed the border between Ukraine and the occupied territories because I had to retrieve some of my belongings. But I did not travel to the territory of Russian Federation. So you traveled to the place where your apartment is? No. I just crossed the border, took back my belongings. It wasn't the territory of Russia. It was the territory of the occupied cities. I never traveled to the territory of Russia. Thank you. Thank you, Volodymyr, for your answer. I'm now passing the floor to our chair. Thank you. Volodymyr, I have quite a lengthy question for you. I need to give some context. Yesterday, the editorial board of Washington Post, not just one journalist, but the whole editorial board, wrote a short article about the events happening in Ukraine. And I will be quoting here, and let me try and translate as I do that. So they are writing this about Ukraine. They are saying that Ukraine failed to create a system that would guarantee the rule of law. And later they are explaining, down below they are explaining why Ukraine failed to achieve that. So they are saying that the main reason for this failure, according to Washington Post, is that the Ukrainian judges are against the judiciary reform. So here comes my question. My colleague Stephen Markman has already formulated this question using a different wording. So you've been a part of the judiciary for a long time, and you've seen all the possible reforms come and go. Do you agree with this statement made in Washington Post, which is quite an influential paper? If you do agree, then what should we do with it? If the system is against being reformed, then perhaps the result of the reform will be questionable. What do you think about this? Thank you. Well, for now, I cannot speak on behalf of the system. I can speak on behalf of myself. I can partly agree. Why? Because at the beginning, we have already established that the level of trust in the judiciary in Ukraine is indeed low. But that's not to say that our judiciary is bad. It's not bad. But as I've already mentioned, the results of its work, the performance of the judiciary is quite low. That's because we are lacking judges. That's because not all decisions are enforced. That is why we have this level of trust, which is low. At the moment, I'm not a part of the judiciary, but while talking to other judges, I can say that many of them are for the reform. They want for it to be completed as soon as possible and for this reform to be successful. That is why I will partly agree with what the newspaper is saying, because there may be judges who don't agree with the reform, but I'm acquainted with many judges who are all for the reform, who want for it to be completed as soon as possible. So this is not the first reform, or at least not the first attempt to reform the Ukrainian judiciary. Why, in your opinion, the previous reforms failed while you were still working as a judge? Because we did have a reform back at that time. Yes, the reform is ongoing. The same reform is ongoing, and we have objective and subjective reasons for the reforms that are incomplete. With regards to qualification assessment, we had some technical issues. We didn't know how to pick the facilities to hold those qualification assessments. So there were some objective reasons for that. At the same time, we had subjective reasons, like the policies of our government, because there was no clear program for the reform, no timeline, no deadline even. If we did have that timeline, then we would have organized the qualifications assessment and we would complete everything within a year and the system would work. But yes, indeed, I agree that practically none of the reforms that we have started had been completed in the past, and that's why we had to initiate new reforms. I think we need to work faster. So we should do it in a similar fashion as we do in the army. You receive an order, and you go and you fulfill it. So if we have a reform, we need to specify the procedure and the timeline, with a set deadline even. And then we are going to have a result, and the result is what matters. That's what I think. Thank you. Your position is clear. Thank you for the answer. Do we have any other questions from our commissioners? Yes, I do have one question. Volodymyr, you as a person who holds a PhD in law, a person who wrote their paper on responsibility for non-enforcement of court decisions, I believe that you understand that the result, that the productiveness of enforcement of court decisions, that's something that's a token of the results of work of the judiciary. So do you think that in order to ensure enforcement of court decisions in Ukraine, with all due respect for people that are currently involved in the system, we do have many concerns about actual enforcement of court judgments, and we can refer to the European practice. How do you think radical strengthening of punishment for non-enforcement, will it result in better levels of enforcement? And what would you say about the structure of a crime under this article? What should the penalty be? What should the punishment be? Could you provide a definition for the structure of this crime? It's not about the sanction, it's not about the punishment, it's not about the article itself. At the time when I was working on my thesis, we didn't have that many cases like that. We had low levels of enforcement, but we didn't have many cases related to non-enforcement. As of 2011, we had several dozens of such cases. I think that we need to have an efficient mechanism for holding someone accountable for non-enforcement of court judgments, for the article of the criminal code to work. Yes, we are speaking the same language because I've dedicated 5 years of my life to the enforcement of court decisions, so I know what I'm talking about. I know how court decisions are enforced, and I know all about non-enforcement. So it's my belief that making the responsibility more severe, and I mean not just legal entities, but also individuals. And here I'm talking not about penalties, but maybe stronger punishments. I think it will result in a higher level of respect for the courts. So, should we have stricter punishments for violation of these rules? Because yes, we can impose some fines, we can impose some penalties, but that doesn't really result in anything. It's not actually a leverage. It's not something that we can use to influence people. Yes, I agree with you completely. Yes, we have responsibility for non-enforcement, and it's both criminal, civil, and administrative responsibility. If we are talking about criminal responsibility, making it stricter, I think it's something that we need to work on, but I think it would be reasonable to make it stricter as far as penalties are concerned. Maybe we could have stricter penalties. Thank you. In the United States, under different categories of cases, we have this efficient instrument of enforcement, which is called bail. So if somebody owes somebody a sum of money, they have the right to appeal the decision only if a bail is placed. If they put a sum of money onto the account of the appellate court, and if a person doesn't do that, they don't have this right. So do you believe that we can use the same instrument in the Ukrainian system? Can we borrow from the S experience? Yes, I think it's a very good example. I think it will be correct for us to borrow this practice. Thank you. Do we have any other questions? Volodymyr, our interview has come to an end. Normally, we give our candidates an opportunity to summarize their interview. Is there anything that you would like to tell us at the end of your interview? Is there anything that you didn't mention? We are giving you the floor for the concluding remarks. I wish the commissioners to have fruitful work as far as the selection of candidates is concerned, the selection of members of HQCJ. I wish you to find people with integrity, people who are professionals and decent people, so that they can make their efficient contribution into having an HQCJ of integrity. And as a result, we will have professional judges selected, judges with integrity, and step by step we will be restoring trust in the judiciary. So I wish you the best of luck in your work. And what can I add?
Let me wish you, let me wish you good and stay safe. Let me wish you health and stay safe. Бажаю вам здоров'я і знаходитися в безпеці. І знаходитись в безпеці.
Дякуємо, пане Володимире.
Thank you, Volodymyr.
Цьому наша співбесіда завершуємо.
This is the end of your interview. Thank you for participation. Best of luck to you and goodbye. Thank you. Thank you. Thank you.